Thank you very much, everyone. And could I say how incredibly important I think it is that we are having discussions like this tonight, and what a major contribution it makes to Australian political debate. And I'd like to start off by saying how much I enjoyed David's words and how insightful they were, and what an important contribution I think he made. I should make it clear that I'll be approaching this issue as a political scientist. Sorry, I'm just setting up my timer. As a political scientist, so I'll be asking you to think about the implications that the issue of same-sex marriage has for the relationship between church and state. In other words, between church, other religious organisations and government. And the first point I want to make is that in Australia, historically, we have tried to have a significant degree of separation between church and state, though there has sometimes been some blurring. And that separation was actually seen as an important guarantee of religious freedom, that government would not be making laws that favoured one religion over another, or indeed, probably even more relevantly at the time, government would not be making laws that favoured one denomination or version of Christianity over another. And that is what Section 116 of the Australian Constitution aims to ensure. The separation between church and state is also why same-sex marriage legislation that has come before the Australian Parliament and that has so far been defeated has made it clear that the question of whom religious organisations should marry, which is clearly an issue of religious conscience, should be left for religious bodies themselves to decide. The same-sex marriage legislation brought before Australian parliaments has therefore always been about whom state-sanctioned marriage celebrants should be able to marry, in a country where marriage is not predominantly a religious institution, given that currently 72.5% of Australians do not get married in a religious ceremony. They get married by a state-sanctioned civil celebrant. And incidentally, for those who oppose same-sex marriage because they identify marriage of a mother and father having children, I would point out that ABS figures also show that over a third of children were born out of wedlock in Australia in 2010. So both heterosexual couples and same-sex couples will continue having children whether they are married or not, as well as many married people not having children at all. The fact that religious organisations will still decide whom they can marry if legislation supporting same-sex marriage is passed is a crucial point to make. It also means that those who still oppose state same-sex marriage on religious grounds are effectively saying that religious organisations should be able to decide whom the state should be able to marry. I'd ask you to think about the broader implications of that position for undermining the separation between church and state. As I say, the separation between church and state was seen as a way of ensuring religious freedom. However, as David has just pointed out, though he doesn't agree with such views himself and spoke very eloquently against them, there are now a number of arguments that oppose same-sex marriage on the grounds that it might infringe religious freedom. For example, that providers of wedding services or goods might be discriminated against if they decide on religious grounds to not provide those services to same-sex couples getting married. Now, there are a few points I'd like to make about this. The first is that, within their own logic, such arguments are not a justification for opposing state-sanctioned civil celebrants being able to marry same-sex couples. At most, they are grounds for arguing that people will support same-sex marriage as long as there are sufficient exemptions to protect those service providers who still want to discriminate against same-sex couples on claimed religious grounds. In that case, what people should be doing is coming up with suggestions for proposed religious exemptions that could be incorporated into forthcoming plebiscites and/or legislation. They shouldn't be opposing same-sex marriage unless they have other grounds. There are precedents for providing religious exemptions, and I do think we need to have a serious and respectful debate about this issue. For example, the Australian Sex Discrimination Act exempts religious educational institutions from unlawful discrimination provisions when it comes to hiring and firing staff and accepting or expelling students on grounds of sexual orientation or marital status where their conduct is not compatible with the tenets of the school's faith. In other words, those religious educational institutions are allowed to discriminate on the grounds of sexuality. However, I would say a few words of caution about going down the exemption path that I'd urge those considering it to take into account. The existing exemptions in the area of religious schools are extremely controversial. As pointed out in the 2015 Australian Human Rights Commission National Consultation 2015 report on resilient individuals, sexual orientation, gender identity and intersex rights, quote, a longitudinal national study into young LGBTI people revealed that 61% of participants experienced verbal abuse and 18% experienced physical abuse. The same report found that 80% of all the abuse reported happened at school. So do think about the impact such religious exemptions can have on vulnerable LGBTI youth who may be already facing quite serious peer harassment at school in a situation where they may risk completely legal expulsion if they try to seek help from their teachers. Just imagine the situation they're in. I'd also ask you to think about some of the implications for the state, for government, if religious exemptions were allowed in regard to same-sex marriage. It is common to hear slippery slope arguments in relation to granting same-sex marriage itself. Some of Senator Cory Bernardi's more colourful comments, which I won't repeat, come to mind. But it is less common to hear slippery slope arguments in relation to providing possible religious exemptions for service providers in the case of same-sex marriage. However, there are some, and I'll run through a few now. For example, you may well be familiar with Leviticus 18.22, quote, "Thou shalt not lie with mankind as with womankind, it is an abomination," unquote. Perhaps a restaurateur might use that to justify a religious belief that they won't provide a wedding reception in their restaurant for two gay men getting married. Perhaps some of you even think that is fair enough. However, what if a restaurateur cited Leviticus 15.19 to 22 to say that they won't let women who are menstruating into their restaurant because, quote, "everything that she sitteth on shall be unclean," unquote, and any man sitting on her chair would then be required to ritually wash himself? Would you consider that to be reasonable? Yet from the state's and a legal point of view, if you set a precedent, why would it be reasonable for 18.22 to be justification for religious exemption and not 15.19 to 27? In the New Testament, you may be familiar with the denouncing of, quote, "vile affections," unquote, in Romans 1.26 and 27, and perhaps believe that should be sufficient justification for a wedding cake maker to argue that they would not provide a wedding cake for a same-sex couple getting married. However, what if the same wedding cake maker cited Romans 7.2 to argue that they wouldn't provide a wedding cake for a heterosexual divorced woman who was remarrying because her husband was still alive and, quote, "A woman which hath an husband is bound by the law to her husband so long as he liveth," unquote. Sorry, I still love the St. James version because the language is so beautiful. Why should one argument be justified and not the other? So the state has dilemmas if it sets precedents for religious exemptions in providing ordinary services. Where does it draw the line? And it isn't just Christianity in question, and it isn't just issues of baking cakes that are in question. What if someone claims, totally unjustifiably incidentally, given what is in mainstream religious texts, that they should be able to carry out female circumcisions in Australia because that is their established religious practice? Internationally, are we going to argue that it is justifiable for those governments and communities overseas that have a religious-inspired death penalty for homosexuality to continue to do so? Or will Australia join the UN in arguing that that is a serious human rights breach? Because after all, Leviticus 20.13 justifies the death penalty for homosexuality. The same-sex examples I give also raise another issue. Why are religious justifications being claimed in order to justify discrimination against married same-sex couples in the provision of services, but other biblical injunctions are being completely ignored? Is David correct when he said just a few minutes ago that, quote, "what we are seeing in the political opposition to same-sex marriage is not so much religious conviction and faithfulness as it is fear and prejudice in search of legitimacy," unquote. Possibly it can be argued that religious schools have a religious vocation and exemptions are justified, though I've indicated just how controversial this is. However, as David points out, being a baker is not a religious vocation. So how come some forms of discrimination in the Bible, for example, against menstruating or divorced women, are clearly seen as not relevant in the modern world, and other forms of discrimination, e.g. against same-sex couples, are? Is there sometimes an underlying homophobia informing such arguments? So I would urge opponents of same-sex marriage to examine their hearts as to what their real motivation is. I'd also ask them to consider the implications of arguing that a particular version of religious belief, which isn't even, as we have heard so eloquently tonight, representative of all religious opinion, why that particular version of religious belief should determine whom the state can marry. And indeed, not only whom the state can marry, but as David also pointed out, try and determine whom religious organisations with other views can marry. Isn't it concerning for a particular version of religious views to dominate the state rather than there being a separation between church and state? I repeat that proposed Australian same-sex marriage legislation has left it up to religious organisations to determine whom they marry. In my considered view as a political scientist, it would be beneficial to the functioning of our democracy if conservative religious organisations did not try to determine whom the state can marry. The state has respected the church. It would be good if the church could similarly respect the state. The separation between church and state is there for very good reason and helps to guarantee not just equal rights, but also important religious freedoms. And I'll leave my talk there.